So we are being recorded. What we would love for you all to do is watch this several times, send it out to as many people as you can in your either your brokerages or your friends, your agents, anybody that wants it. We will have it out to our members. We'll upload it and send it out. Or hopefully it will be able to be uploaded on our website too, but we'll let the members know. Give us a couple days. Next week, we'll have to convert it and get it out. So look for that in your emails. Also, this is not a CE class, so you can basically be on camera, off camera, but we ask that everybody be muted unless you're asking a question, or if you want to put it in the chat. Laura and I will be checking. Laura Metz, who's on, our Director of Operations, Danielle Lepo, will be in and out of the session. So we'll be monitoring things and looking at the chat. If you put a question in the chat, James has said that he will be able to ask questions or answer questions as he's going through the process. So we will either read the chat, or if you want to just unmute yourself and be respectful. Hopefully we won't have 5 people asking a question at the same time. So we'll keep that all monitored and everything. As we said, this is not a CE class, so you don't need to be on your camera. But as I mentioned, we have 90 some people who are going to be on there, hopefully beyond the class. So with that, I would like to introduce our guest speaker today. Excuse me. James Bieslet is an associate counsel for the Legal Affairs Department of Maryland Realtors, in addition to serving as a prime staff liaison to the statewide Forms Committee. James teaches continuing education classes and speaks at a variety of events focused on real estate law and regulatory issues. He also creates written and digital content for the association's communications platform and staff, and the legal hotline services together with other legal affairs attorneys. He is a graduate of the University of Baltimore School of Law and resides in historical Federal Hill in Baltimore City. And in his spare time, he probably sleeps, I think, right? That's about all the time you have for. So with that, I will let you take it away, James. Thank you.
Great. Thank you so much, Kathy, for that introduction. And yes, in my very limited spare time these days, I tend to go straight to bed once I get home. But thank you so much for that welcome. I've been spending a lot of time with our HARCAR folks over the last few weeks between your officer installation and some other events I've seen your members at. And I'm certainly happy to be here with all of you today virtually to talk about our statewide forms. As Kathy said, I am an associate counsel in our legal affairs department, and a big part of what I do is work directly with our statewide forms committee. So that's a committee made up of members from across the state of Maryland, including the ones that Kathy gave shout outs to earlier. And those members are responsible for considering proposals that we receive from our general membership to either perform updates or consider revisions or create brand new statewide forms. And I just counted earlier today, we have 80 forms and templates in our statewide forms library. That is a lot of forms. And of course, what our goal is to provide as many documents as we can that may be applicable to as broad a number of properties as we can on a statewide basis. Of course, I travel all across the state doing talks like this, but also teaching continuing education classes. And certainly properties across the state vary in so many different ways. And that's one of the things I'll be talking about over the course of this review of our contract and some of our more commonly used addenda, forms that have been updated or are new for this year. We do try and shoot for general applicability. That sometimes means that we have a lot of information in our contract of sale, for example, that might not be specifically applicable to the property you're working with, but we keep a lot of that information in there so that we can meet that goal of general statewide applicability. Further to what Kathy mentioned about creating content for our communications platforms. So I'm going to go ahead and put a link here. I understand today's session is being recorded and will be available on HARCAR's website, which is great. Can I make the sound louder? I'm talking at a normal tone. Yeah, I think if you're having volume issues, go ahead and turn the volume up on your personal device. But in the chat, I just put a link to our YouTube channel at Maryland Realtors, and we have a number of video resources available for all of you in connection with this statewide forms update, including a discussion that I recorded with our Director of Legal Affairs, Kathleen D'Artez, where we go through all of the changes, as well as a series of shorter videos where we discuss some of the larger changes. And those are all available on our YouTube channel as an additional resource for all of you. And of course, as those of you who are familiar with our website know, all of our statewide forms are available on our website at mdrealtor.org. If you go to the legal tab at the top of the page and then click statewide forms, that's where you will find copies of all of those documents.
James,
Before
Daniel had a question. Do you want to spotlight you when you're sharing all of your documents? So will you be sharing a lot of documents up on this screen?
Yep, and I've got the screen share button. It looks like it's working, so I'll be getting to that part pretty short.
Okay.
Yeah, but thank you so much.
Okay, not a problem. Thank you.
So briefly before I jump into our contract of sale, I also just want to make a plug for our legal hotline service. That is something that is available to all of you here as a member benefit, as a Maryland Realtors member benefit. We are on the phones live Mondays, Wednesdays, and Fridays from 10 to 12 and 2 to 4 generally, as well as we receive questions through our website that you can submit electronically in writing 24/7. We just ask that you give us a couple of days to respond to electronic questions. But we certainly can answer general legal information type questions about our forms, as well as any number of other types of topics. And certainly as we go through today's forms, the focus, of course, is on new content changes, but there are points where you might hear me start talking about some general tips, things to be mindful of as you're filling these documents out, assisting your clients. That's a huge part of what I do working at Maryland Realtors, is helping our members understand the best practices, if you will. So that'll be a huge part of what we talk about today. And as Kathy said, if you have a question, I think the easiest way to manage questions with a group of this size, looks like we have 50 participants at this point, and I imagine more people are going to trickle in. Go ahead and put your questions in the chat, and periodically I'll do my best to take a look and we'll kind of answer questions as we go. And with that, I'm going to go ahead and share my screen. I'll be sharing a number of different documents over the course of the class. So just bear with me as I toggle through some different documents.
And Laura and I will be watching the chats too.
Wonderful. Thanks so much, Kathy. So starting off with our contract of sale. And when I think about member benefits for Maryland Realtors members, the two that come to mind, the two most commonly used member benefits: forms, legal hotline. Those are things that I, of course, interface with the most, but I would say, our residential contract of sale form is one of the most commonly used member benefits. Our goal, of course, is for this contract to be the most commonly used contract out there in the state of Maryland. I certainly understand there are some other form contracts out there, but generally speaking, this is the contract you see, the consumers see when they are engaging in a residential real estate transaction. This was my very first exposure to Maryland Realtors when I bought my own first home last year in February of 2021, seeing this contract, seeing the logo, and understanding what that meant. Little did I know, 3 or 4 months later, would I be actually working for the association whose form contract I used to buy my home. Small world. So when it comes to the contract of sale and this year's changes, they were more substantive. There's a lot more going on this year than has been the case in previous years. And that is because that our immediate former president of our statewide association, Craig Wolf, assembled a task force of members from across the state, mostly brokers and office managers, some of our most experienced members, to take a deep dive, if you will, into some of our most commonly used forms, including our contract of sale, and brainstorm recommendations for how those forms might be improved, from the top down level, from a 60,000 altitude, if you will, 60,000 foot view up top, and then down to, some more detailed changes, if you will. That task force worked over the course of, I'd say, about 8 months or so, 8 or 9 months. And their work culminated in a set of recommendations that were put to the statewide forms committee, of which Cleo Pappas was our chair last year and of course remains a member. And our statewide forms committee had the opportunity over the course of 2 meetings to consider all of those recommended changes, and the vast majority of them were implemented upon their approval by our executive committee. So between the executive committee's approval at the end of July and the release on October 1, as well as the sort of incremental release of training materials in September, I have been very busy, and our members have been very eager, and I've been gratified by that, very eager to learn about these new changes to our forms. One of the very biggest things that you'll notice right away when you're looking at the contract of sale is the fact that we now have sections, right? We have 7 different sections, beginning, of course, as you can see here on page 1, with general contract provisions. As we go through this form, you'll see some items are highlighted. What I really want to hit home with the contract of sale is that a lot of the content within the contract that we've had for years, that has worked well for years, has not changed. It may just be in a different place. That is because one of the goals of the task force was to bring some degree of organizational methodology to the contract. One of the first things I noticed as a first-time Maryland homebuyer when I was looking at this form for the very first time was that a lot of unrelated provisions were kind of interspersed throughout the contract, such that it could be difficult to find something that you were looking for quickly. And I think that that particular goal of the task force was achieved very well by the implementation of sections. So content that we already had was organized throughout the contract of sale. And I think that's one of the very biggest changes and something that people notice right away. So diving into section 1, this is where you're going to have the vast majority of material terms to a contract, things that absolutely need to be included in defined terms. The very first thing you might notice here, time is of the essence. So this is a critical provision to our contract of sale. And previously it existed as a boxed paragraph, one of those boxes at the very top of the form. Nothing has changed in this regard. It's still a critical portion of our contract, but we believed it was prudent for it to have its own paragraph number and not be sort of floating at the top of the form. Still towards the top, still very important, but it's just now paragraph 2. As you go through the very first page, you'll notice, again, those material terms: name of the seller, name of the buyer, identification of the property, the type of estate being conveyed, the purchase price, payment terms. This is, of course, where any deposit monies are addressed in the contract. And one thing that I tend to highlight at this point in these sessions that I've been teaching is the importance of escrow agreements when a title company may be holding an earnest money deposit. This is something that has come up quite frequently on the legal hotline over the last several months in various questions and various forms with different fact patterns, but something I really want to emphasize here. It is becoming increasingly common for buyers to have their earnest money deposit held by a title company. And in fact, on the flip side of that, I know of some brokerages that are no longer holding earnest money deposits. They do not want to be in that business. They require that a buyer have that held by a title company, and that's fine. But of course, if a title company is going to be holding that earnest money deposit, you have to have that escrow agreement executed by the buyer, seller, and the escrow agent, the title company. And that is stated right here in bold under paragraph 8C. If the deposit will not be held by a Maryland licensed real estate broker, the party shall execute that separate written escrow agreement. Now, why is that? What is the purpose of that escrow agreement? So under the Maryland Real Estate Brokers Act, when a broker is holding the earnest money deposit, that broker is subject to statutory provisions. They're subject to certain standards for maintaining and depositing those monies. And they're also subject to certain dispute resolution mechanisms. They have certain tools at their disposal, if you will, in accordance with the statute to handle disputes. So those of you who may have been involved in a transaction that ultimately failed may be familiar with the 30-day letter or the broker's ability to file an action for interpleader in the court, essentially taking that disputed funds taking those disputed funds out of their deposit account, their trust account, and depositing them with the court and saying, court, the parties cannot agree to how this earnest money is going to be distributed, so this is now a matter for the courts. However, when it comes to escrow agents, there is no statutory framework like that for them. So what is required is that any dispute resolution mechanisms and standards for maintaining those EMDs be contained within the escrow agreement. And we have an escrow agreement in our statewide forms library. We developed it in concert with the Maryland Land Title Association. I believe that form was released a couple of years ago. And certainly it must be used and included when a buyer is having that EMD held by the title company. I do get calls on the legal hotline. Two types of calls in particular in this regard. One, well, it's a couple of days after the buyer was supposed to make that EMD deposit, and I have learned that the deposit was never made. Can the seller get out of the transaction? Absolutely. That is a breach of the contract if the buyer does not timely make that earnest money deposit, such that that gives the seller the ability to unilaterally terminate the contract. Certainly a good best practice is for agents to be following up with whoever is meant to be holding that EMD and confirming whether or not it's in fact been deposited on time. But the more common question that I've been getting that troubles me is something along the lines of, well, we're under contract and now there's a dispute, and one of the parties wants to make a claim against the EMD. It's being held by a title company, but whoops, we forgot to execute an escrow agreement. What happens? Well, that's a great question, because you have not bound the title company to follow any sort of rules, if you will, procedure for handling that dispute. So that is very much a problem, and one that's, again, easily avoided by incorporating that escrow agreement into the documents to be executed if, again, that EMD is going to be held by a title company. Moving forward into paragraph, or rather through the rest of page 1, we have our standard deposit paragraph language. This has not changed. It's just now on page 1, date of settlement. And then going into page 2, our addenda and disclosures paragraph. So you'll see a few highlighted lines here. On the left-hand column, those addenda, the additional as-is provisions, the ATU, BAT, as well as the inclusions, exclusions, leased items, and utilities documents, those are all brand new to the statewide forms library. The tenant occupied addendum on the right-hand side, that actually is a form we've had in our statewide forms library for some time, but was not referenced here in this paragraph. And given its importance, again, that's a form that should be used by sellers to disclose the fact that their property is tenant occupied, so that buyers are on notice of that and also have access to copies of leases, other important information that they should be aware of especially if they're going to be taking possession of the property with a tenant in place. So there now is a place to incorporate that addendum into a contract of sale. I'm going to talk about the additional as-is provisions and ATU, BAT documents a little bit later. I will take a pause here from the contract of sale and talk about the disclosure of inclusions, exclusions, leased items, and utilities addendum, because this is an important form. This was conceived entirely by the statewide forms committee, and it was really in response to what I've called in past sessions sort of like that game of telephone regarding inclusions and exclusions. Because typically you would start off with an addendum to our brokerage agreement, to our listing agreement, that had a seller indicate what items were to be included, as well as what utility serves the property. Then the listing agent would look at that form and take that information and put it into the MLS. The buyer's agent, for a prospective buyer, would see that in the MLS and take what's in the MLS, put it into what was old paragraph 13 in the contract of sale. That would be made part of the offer. A lot of points, links in the chain, if you will, where there was potential for data entry or errors that would ultimately sometimes result in the wrong information being made part of a contract of sale, and suddenly perhaps something that a seller did not intend to convey is conveying with the sale. One way that we sought to alleviate this was by sort of consolidating that process and creating a one-stop shop, if you will. So that led us to creating this form on one page that allows the seller to disclose all information pertaining to what they plan to exclude, or rather include in a transaction, information pertaining to any leased items that are going to convey with the sale, as well as utilities that service the property. All contained on one form, a form that can be made part of the contract of sale. So certainly envision this form being uploaded to Bright such that it's available to prospective buyers through their agents, and can be included with the documents submitted to a seller as an offer. If you've listed a property and you've had a property listed prior to September 30th, prior to October 1, it would be prudent to have them fill out and execute this form and put this up on Bright so that buyer's agents using our new contract can include this document, because of course, as part of this change, paragraph 13, the place within the body of the contract that had all those check boxes, that is gone. So this is where inclusions and exclusions are to be made part of the contract of sale by using this form. All right, shifting back to the contract of sale itself. As I said, some changes are of larger scale than others. You'll note that we used to have separate paragraphs in our old contract that covered conducting the transaction electronically and using electronic signatures. We've consolidated those paragraphs into one paragraph. That is why paragraph 12 is highlighted. But beyond that, as I referenced earlier, a lot of our verbiage has not changed. It's just in a different place. So provisions pertaining to the entire agreement, the computation of days, seller responsibility, while they may be in different places, they have not changed. We did make a slight tweak to the leases paragraph, just incorporating a representation of the seller that the property is not tenant occupied unless that information is conveyed in an attached, tenant occupied addendum. That is the document that should be used if a seller is seeking to sell their tenant occupied property, and in particular, if that property is going to remain tenant occupied after the transaction closes. Remember in this regard that the simple conveyance of a property, the sale of a property, is not a basis for a tenant to lose their right to occupy the property. That's not how that works. Leases survive property conveyances. So if I leased a house tomorrow and the following month the seller decides to sell and I have a 1-year lease in place, I go with the property. I get to maintain my right to occupy the property pursuant to that lease. Whether or not the new owner decides to renew the lease, of course, is a completely separate matter. Shifting down to section 2, I typically don't spend too much time here because none of these provisions have really changed. They've just now, again, been concentrated into one place. So all provisions pertaining to the payment of the purchase price, so how the property is going to be financed, our financing application and commitment paragraph, buyer responsibility, provisions pertaining to sales settlement or lease of other real estate, and the buyer's right to pursue alternate financing, all contained here in section 2 now in one place. Section 3, property condition and inspections. So this is where I tend to have sort of a broader conversation about property inspections, the documents associated with property inspections, what an as-is transaction is, our now retired as-is addendum. And so let's dive into all of that. I've polled a lot of members across the state as I've been doing some of these sessions, asking them, what does it mean when a property is being sold as is, right? We see that quite frequently in listings, quite frequently discussed amongst some of our seller clients. And it comes in different flavors too, right? I often see the phrase strictly as is. I don't know what strictly as is means. As is as is, right? But often I see a lot of qualifiers on that as well, qualifying terms, descriptive terms, which add to the interesting nature of this topic. But generally speaking, the broad consensus that I've come to understood and that was my understanding as well as to what an as-is transaction is a transaction where a seller is representing that they are not going to make any repairs, they are not going to offer any credits. The property is being sold in the state it is in on the date of contract acceptance, as is, right? And indeed, that was the intended purpose of our as is addendum, right? As evidenced by the title, as is addendum. And that form came into existence, say about 12 or 13 years ago in the wake of the Great Recession. And it was intended to put buyers on notice and allow the parties to agree that the property would be sold in as is condition. It deleted certain provisions of our contract of sale, so provisions pertaining to the delivery of the property free and clear of trash and debris and broom clean, that was deleted. The termite paragraph that used to exist in our contract of sale, that was deleted. And it allowed the parties to agree that on one option was that the property was being sold as is. There was no potential for inspections or termination. That was subparagraph A. But much more commonly used was subparagraph B. That allowed the parties to agree that the buyer would have the opportunity to conduct whatever inspections they wished, and based on the results of any of those inspections, unsatisfactory results, terminate the contract, although they didn't have to specify the basis as to why they were terminating. They just had that unilateral, unconditional right to terminate the contract, all within one agreed upon time frame, right? We all are familiar with that form. However, that form was not used for its intended purposes in a lot of cases. So that form did not contain a contractual framework for negotiating repairs or credits, right? Because it's meant to be an as-is form to support an as-is transaction. However, often buyers would use that form. That form would be included in offers as a way to make that offer appear more compelling to sellers who were under the impression that they would not have to be doing any repairs or offering any credits in connection with the results of an inspection. In fact, most sellers believe they wouldn't be receiving any inspection reports or any information pertaining to the results of an inspection. That simply wasn't the case. I would receive many calls, hear of many transactions where a buyer, upon receiving the results of an inspection, would have their agent contact the listing agent and say, well, the buyer's prepared to walk unless the seller does X, Y, and Z, or offers this amount in credit, or we do something. We modify the terms of the contract in some way. And so suddenly a seller who thought they were selling their property as is in a position where they're either going to lose that buyer or they're going to have to agree to do certain things. And all the while they're negotiating sort of outside the terms of the contract, outside the framework as provided for the contract. Remember that the property inspections notice was not designed to be used with the as-is addendum. There was no basis to use that form with an as-is addendum, although frequently I would get calls. Well, we just received a property inspections notice, but we have an as-is addendum made part of the contract. What do we do? So all told, when the statewide forms committee and the task force were thinking about how the as-is addendum was meant to be used, what its intended purpose was versus how it is used, that form was just not working, such that it was decided that it would be retired. So where does that leave us in terms of as-is transactions? So now's a good time to shift over to the property inspections addendum. I will note first, so you'll notice that the termite inspection and repair and remediation language that we used to have in the contract of sale was removed and deleted, and that was in an effort to bring our contract of sale, the body of our contract of sale, closer to a true as-is contract. And certainly, if there were mechanisms for repair of termite damage within the body of the contract, no transaction was really as is, unless that as is addendum was attached. But without that as is addendum anymore, we're left with wood destroying insect inspections being negotiated as part of the property inspections process here in line 7. And here is the new property inspections addendum. So there were a few issues with the outgoing property inspections addendum that the task force sought to address as well. First, we had paragraph 4B. Those of you familiar with the old property inspections addendum probably remember that as the boxed paragraph, another box. No legal significance to boxes, by the way. I'm not quite sure where that came from, but There we go. No more box paragraph, but that paragraph, if the parties agreed to it, so you were looking there in that case for an agreement within an agreement, right? You have the addendum, which is being made part of the contract, but you had to get the parties to specifically agree that that provision would apply to that transaction. And what that paragraph did was give the buyer the unconditional unilateral right to terminate the contract based on the results of an inspection. That paragraph was almost never used. Very rarely did we see that provision being incorporated into a contract of sale, which left buyers who included a property inspections addendum as part of their transaction with very limited options. So in terms of what they could do once they had completed an inspection. So if they completed an inspection and they were completely dissatisfied with or unhappy or uncomfortable even with the results of an inspection, there was no way for them to get out of the transaction at that point. And I'm thinking of specifically the example that I use in these sessions is mold. A lot of buyers are hypersensitive to mold, and for good reason, but certainly have been made aware of a lot of transactions where buyers simply do not want to proceed. They don't care what a seller may be willing to do to remediate or repair that condition or certain other types of conditions. They simply want out of the transaction. So what would buyers do in that situation to get out of a transaction? Oftentimes they would submit requests for repairs, quite long requests for repairs, perhaps identifying every deficient condition on a property inspection report, such that a seller would be presented with that and not want to do all of those things. And as we all know, if a seller does not agree to do everything that a buyer is requesting pursuant to a property inspections addendum, that gives the buyer the ability to terminate the contract anyway. Except now the seller and their listing agent are on notice of perhaps a broad scope of issues with the property, issues that might constitute latent defects that a seller is obligated to disclose. And remember, a latent defect is a condition that's not readily ascertainable by a careful visual inspection of the property and is something that could pose harm or health risk to a buyer or any occupants of the property or any of the buyer's invitees. That's something that sellers have to disclose. And certainly if a seller becomes aware of a latent defect over the course of a transaction or by way of a failed transaction, they have to update their Maryland residential property disclosure and disclaimer statement. For real estate licensees, it's even broader. We have a statutory obligation and an obligation set forth in the Maryland Code of Ethics to disclose material facts that we know or should have known about a property for which we accept agency or are dealing with. That is a very broad disclosure obligation, and certainly many things that might come up on an inspection report could constitute material facts that are then in turn subject to disclosure to prospective buyers. So that was a major issue of the old property inspection addendum. Another issue that would come up quite frequently, and you'll see here in the new one, well, rather under the old one, each type of inspection had a different time frame for completion, such that, for example, you could have 5 days to do a structural and mechanical inspection versus 10 days to do a chimney inspection. So you would be in a position where you would have to send multiple property inspections notices to sellers. Sellers don't have the opportunity to consider all of a buyer's requested repairs at once because you have these different time standards. And you're then having to keep track of different timeframes for completing inspections, negotiating repairs. It was certainly something that was raised to us as an issue over the course of reviewing prospective changes. So let's see. Shifting to the new version of the property inspections addendum, discussing that substantively. So rather than have separate deadlines for completing each individual inspection, we now have one master deadline, if you will. So the buyer and seller will agree that the buyer will have the right to conduct any of these inspections that are agreed to by the parties within a certain number of days, one controlling time frame. And that final day is referred to as the deadline. So we have all the different types of inspections here. A couple of points that I'll note. It's still the case that future condition and performance of systems and components is not warranted by the seller. It's still the case that inspections are not meant to be inclusive of items of routine maintenance or a cosmetic nature. So scuffed floors, dinged appliances, that's not part of the property inspections process. Items of routine maintenance certainly also not part of the scope of what can be requested by a buyer.
James, we do have a question. Why aren't the well and septic inspection on this page for notice?
So well, and you'll see here in the notes at the bottom, inspections for well and septic are handled through separate addenda. So we have our on-site sewage disposal system addendum. We have our well yield test addendum and our water quality addendum. This is the property inspections addendum. There is a corresponding property inspections notice that I will talk about later. That notice does not cover well and septic. Neither did the notice that previously existed. It has been proposed to create notice forms for those separate testing addenda. Again, OSDS, on-site sewage disposal system, and water yield and quality. So that's an update that you will likely see in the next year. But those tests, if a property is going to be subject to a septic inspection or some type of water quality or yield inspection or test for a well, those are separate addenda.
Thank you.
Of course. So that brings us right here to the notes. And here's a good time to talk about an update that took place over the summer. For those of you who have worked with VA buyers or have otherwise been involved in a transaction subject to VA financing, you'll recall that it used to be the case that VA buyers were not permitted, pursuant to VA policy, to pay for wood destroying insect inspections or repairs. And those inspections are required by the VA for VA financing. On June 15th, 2022, that policy changed. The VA changed their policy. So the policy is now that VA buyers may pay for those inspections and they may pay for such repairs. So certainly, I do see now VA buyers as routine, paying for those inspections. I think that change was made in part to make VA buyers a bit more competitive in the marketplace. I know from calls that I've received, again, a lot of my experience here working at Maryland Realtors is informed from the legal hotline. I speak to no fewer than 30 agents on a weekly basis, asking me questions on any number of type of topics. But certainly the prospect of having to pay for a buyer's wood destroying insect inspection or a buyer not being able to pay for any repairs in that regard was not always appealing to sellers. So I think this makes VA buyers a bit more competitive, this policy change that came from the VA. And that policy is also referenced as part of the VA financing addendum. Remember that conducting that wood destroying insect inspection is a requirement for the VA financing. It is a requirement of the VA. Shifting down to paragraph 1B, this is where I would say that there's been a lot of questions about this change. So we discussed in the old addendum, we had paragraph 4B that was never used. A lot of issues could stem from a buyer not having the ability to get out of a contract upon receiving results of an inspection that are unsatisfactory. It was discussed quite a length amongst members of the task force and the statewide forms committee, but it was ultimately decided to incorporate a buyer's right to terminate into the body of the contract. So there doesn't have to be a separate agreement granting the buyer that right. I have fielded a lot of questions from members about, well, okay, what if that is stricken? What if we strike paragraph B1 here? Well, I would never represent that I would endorse anyone striking or modifying the terms of our forms, although I concede and totally understand that people do that. That being said, you then run into the potential issue, as I described earlier. If a buyer doesn't have the right to terminate after conducting an inspection, they are then forced to negotiate repairs. And if I were a savvy buyer seeking to get out of a contract because I didn't like the fact that the mold report came back with lots of mold, or there were structural deficiencies with the house, or other serious issues that I simply did not want or did not, care if a seller was willing to remedy them, I would simply request each and every item that came up on all of my inspection reports. And so long as the seller did not do exactly what I requested, I would then have the ability to terminate the contract. So the seller is left, all the way back at square one. Buyers left, ultimately walked away. And on top of that, the seller has knowledge of a lot of conditions of their property that they perhaps wish they did not have. So that is the risk, the main risk, I'd say, of striking out this right to terminate. But moving forward with negotiation and exercising one of these two rights, either the right to terminate or the right to negotiate needs to be elected by the deadline, right? So you have a certain number of days to conduct all the inspections, and then you need to decide as a buyer whether you want to negotiate those repairs or in fact terminate the contract. And you pick one or the other within the time frame of the deadline. Once you pick one, you cannot go back and change your mind. So if you terminate the contract is terminated, the deal is dead. If you decide to negotiate by submitting that written request for repairs, you are now down the yellow brick road of negotiation. You cannot go back. You cannot click your heels 3 times and terminate the contract if you change your mind before that deadline period expires, if you happen to submit that written request for repairs prior to the deadline, a few days prior to the deadline, for example. Once you elect to negotiate by sending that written request for repairs, you're down that path. And that path is set forth in the next section. So once that written request for repairs is submitted, the seller has 5 days to consider that written request. They then have the opportunity to respond within that time frame, and if they agree to do everything the buyer requests, you're done. You move forward. The contract moves forward. If the seller doesn't agree to everything the buyer requests exactly as the buyer requested it, that gives the buyer the ability to either take what the seller is willing to offer and move on, terminate the contract, or now the buyer does have the ability to submit a further counter offer to a seller to see if, well, for example, the seller offers to do A, B, and C. Buyer says, well, okay, I hear you. I don't want to terminate the contract, but are you also willing to do D? So there's a little bit more of a framework built in for back and forth in the property inspections negotiation process. Of course, we understand that a lot of this negotiation happens in the background between agents, which is totally fine. But of course, the full and final agreement needs to be memorialized in writing in accordance with these timeframes set forth in the addendum. Something to bear in mind. Kathy, any questions I could address at this point?
No, we're looking good. Hold on. Well, just as you said that. Steve, if you want to jump on and ask the question, that would be great. It's kind of long.
Okay, you there? Can you hear me?
Yeah, we can hear
Okay,
you.
so my question basically is how would you handle a situation where, a home inspector recommends additional inspections and now your time frame is up. But with the old inspection form, you could put on, this inspection 7 days, this inspection 21 days, any additional inspections that the home inspector recommends, we're adding, an extra 14 days for those inspections. Now it's all encompassed under one. And I can tell you from experience, a lot of times sellers won't accept an inspection period of say 21 days or something like that. They're like, oh, you have 7 days to do your inspections, and it's unrealistic, and you can lose a contract because of that. That's why I prefer the old form for that reason.
So in the situation you described with the old form, and let me just go ahead, go back in time, if you will, in my forms, because I would love to address your question with the old property inspections addendum in front of me. Let's see here. So this is the old form, and as I described, you had different time frames from the date of contract acceptance for each inspection, and certainly here was additional inspections. So you could conceivably put, for example, structural and mechanical 5 days, and then you could put 14 days for additional inspections. So if you're now putting 14 days for that full deadline, it's really no different in the sense that a seller is on notice of the fact that a buyer has 14 days to conduct any additional inspections that may be recommended by that first inspector, and submit additional property inspections notices based on the results of those inspections. So the overall inspection contingency timeframe is really the same. If a buyer is contemplating wanting to be able to conduct additional inspections, they're going to have to build that into their contemplated timeframe, that overall deadline, just as they would have had to incorporate a different deadline, an additional deadline, into the old property inspections addendum.
Okay, so typically, from what I remember, is we would basically say there was like an agent would put on there any additional inspections recommended by, you know, the main home inspector, the structural mechanical home inspector, and you'd have an additional time period to do that if you needed it. Whereas like basically they don't want you, you know, where sellers seem to have an issue is, oh, you have 21 days to do your regular home inspection, you know, on the property. Whereas, okay, we'll give you 7 days to do the regular home inspection. And if there's any issues that come arise, then we'll give you an additional time period to complete the rest of them.
Right. So that was, I mean, if folks were writing their own addenda to accomplish that, you know, that's what they're doing. That was not how our old form was really designed. Frankly, the old form and the new form, the additional inspections lines, really the way they're drafted is to not achieve what is often done, which is open the door to any other potential type of inspection that a structural and mechanical inspector, for example, recommends,
Mhm,
to allow the parties to do different types of inspections that are not stated on the form. For example, like a pool inspection,
mhm.
some other type of inspection that might not be stated. So this whole additional inspections issue, I mean, I have received some feedback similar to what you've relayed here, and I certainly, you know, take it and take note of it. But at the
Yeah,
end
'cause-
at the end of the day, the inspection time frame, if it's going to exceed the initial time frame that's granted for one type of inspection, we've just sort of encompassed that in one time frame. In this, using this form as it's stated, the old property inspections addendum, if you had, for example, 5 days for structural and mechanical,
mhm.
then what, 14 days for additional inspections. As a seller, I'm looking at that and saying, well, I guess we're not going to be done for 14 days. Am
Yeah,
I
I
okay
hear
with
what you're
that?
saying. I definitely hear what you're saying. Having said that, I think it's more of a peace of mind thing than an actual reality thing. If someone has, you know, the two inspection or two different boxes checked, and on the additional inspections they have, um, you know, any additional inspections that the initial home inspector recommends, and they have 14 days to do that. Well, the seller's thinking, okay, they're going to have the regular home inspection unless something crazy comes up. You know, this will be completed in 7 days, as opposed to, wow, you have 21 days or 14 days to do a home inspection. We want to know what's going on and if you're going to buy this house or not, you know, by 5 days or 7 days, not 14 days or 21 days.
That being said, the way that this is worded, I could make a request based on the initial structural and mechanical within 5 days, and then I could wait till day 12, do an additional inspection, and then on day 14, submit another property inspections notice. There's nothing
Yeah.
preventing me from doing that. So
Okay.
that, you know, sense of security that you just described might be a little off.
Yeah, I'm not saying it's accurate. I'm just saying or it would hold up. I'm just saying that it's more of a peace of mind thing or ease of thing, you know, for ease for a seller to
Right.
swallow a 21-day inspection period as opposed to a 5 or a 7 day.
Right.
Because they
Okay.
want to know right away, is this, you know, are you going to buy it or can we get it back on the market or what, you know?
Sure. I guess I hear you. It's just what you're describing, knowing that they can get it back on the market. They wouldn't know that until the 14-day
Yeah.
period and the old form was over.
Hmm.
Wouldn't know that.
Okay.
We do have one other question. What is the time frame for the counter offer on B?
So we're operating on a 2-day time frame, and I'll shift back over here. So all negotiations beyond the seller's 5 days to respond, 2 days. You got 2 days. The buyer has 2 days to consider whether they want to accept what the seller is willing to offer, terminate the contract, or make a counteroffer. If they do choose to make a counteroffer, that seller has 2 days to respond, and so on and so forth. I'm not, they built that additional flexibility. They wanted to build that additional flexibility into the form. Buyers and sellers don't necessarily have to continue down that path. They don't have to take advantage of that. It depends on the nature of the transaction and what the party's appetite for negotiating these things is. I'll just go ahead and touch on the property inspections notice. I mean, this document has largely stayed the same, except it now incorporates space to memorialize the potential for those counteroffers that I was just discussing in writing. So of course you state, what inspections were agreed to in the property inspections addendum, space for that initial notice from buyer to seller, attaching copies of the inspection report and noting the list of unsatisfactory conditions. Further, the response from the seller to buyer, completing the corrective action specified, not completing anything, or agreeing to do some but not all of the things, and or offer a credit. And then that response from buyer to seller, either accepting the seller's response, accepting the offer of a credit, terminating the contract, or proposing that further written counteroffer. And there is space for a couple of back and forths of counteroffers. Of course, we didn't want to go infinite, but if that is something that occurs in your transaction, there is space to memorialize those negotiations. A couple of things I want to point out before I shift gears. One member called me on the hotline and was concerned that the seller now had the right to be present during home inspections. And I had to gently remind that member that they've always had the right to be present during the home inspections. Would I necessarily recommend that a seller be present during a home inspection? Probably not. But very careful reading of these forms, so critical. And one of the sort of extra benefits I've seen to some of the more substantial changes this year is it has encouraged our members to read very carefully and go through a lot of these documents that they may not have read through in recent months or even years. So I think that's been an added plus, if you will, to some of this process. Let's see. I see another question from Steve. To clarify the as-is clause, even after inspections are done or agreed upon completed, when going to settlement, are they still buying the property as is with no warranty? Yeah, so the seller does not warrant future condition of any of these items. There's no warranty for any of these items. It's an as-is transaction, but of course they have negotiated inspections and repairs pursuant to those inspections. All right. So back to property condition paragraph. So I referenced this earlier, but in the inclusions exclusions paragraph now, it makes specific reference that you're going to need to have that disclosure of inclusions, exclusions, leased items, and utilities addendum attached to discuss specific items that a seller may be including or excluding. Condition of the property. So we do still have a provision that the seller shall deliver possession of the property vacant, clear of trash and debris, and broom clean. And it's substantially the same condition as existed on the date of contract acceptance. So what does that mean? I get a lot of questions in this regard, especially when an as-is addendum was attached, but substantially the same condition as existed on the date of contract acceptance. If a tree falls on the house over the course of the transaction, house has to be sold with that damage repaired. Can't be a tree on the house or the garage because that likely did not exist on the date of contract acceptance. Of course, if that inspection addendum or any of the well or septic addenda, test addenda are being made part of the contract, it should be initialed here by the buyer that those inspection addenda are attached in paragraph 26.
We did have another question. It says, where is that in writing?
Where is what in writing?
Yeah, Tina, if you want to jump on real quick. Because I think that was back in one of your conversations.
Yeah, it was in the previous conversation. When we were, I just didn't realize in that paragraph 25 that saying the property was sold as is. So I'm clear on that now.
Oh, cool. All right. Moving on to sections 4 and 5. I don't spend a ton of time talking about these sections in these classes because, as I've said a few times now, these sections contain a lot of information that was already in the contract. It's simply now been concentrated into these sections because they are like provisions. They are similar provisions under these various headings. So in section 4, property specific disclosures, we did tweak the homeowners association paragraph to incorporate reference to condominium regimes, emphasizing the importance, if a seller is selling a property that's part of a condominium or an HOA, of course, sellers have certain notice and disclosure obligations, and buyers have certain rights in that regard. I'd love to get a quick poll in the chat. How many days does a seller, or rather does a buyer, have to terminate a contract once they have had the resale package delivered to them for a condominium? How many days do they have? Anyone wants to put answers in the chat? That would be cool.
I can read them as they put them in. I guess nobody wants to, to do it.
I see someone said 3. So remember, if once the seller has delivered that resale package in a condominium to a buyer, Roseanne's got it. 7 days. 7 days. And Sandy, that answer will be right in just a second. So the number of days that a buyer has to exercise a right to terminate if they're purchasing a property subject to a homeowners association. Yep, Jim's got it down. 7 for condo. It's 5 days if the property is part of a homeowners association. Something that's very important to be cognizant of if you are listing a condo or an HOA or working with a buyer to purchase a property that is part of a condo or an HOA. Where it gets even more confusing, though, is when sellers have to deliver those resale packages, right? So if the property is part of an HOA, parties go under contract, the seller has 20 days from the date of contract acceptance to deliver all of the documents and information that a buyer is entitled to receive. Once those documents have been delivered to the buyer has 5 days in which they may terminate the contract. That's for HOA properties. Condominiums, that time frame, that deadline, if you will, for delivering the documents, it's not calculated from the date of contract acceptance. It's calculated from the other end of the transaction, from the settlement date, which is very strange to me. I'm not sure what our legislators were thinking back in the 80s when they were drafting the Condo and HOA Acts. Of course, condos and HOAs are very different animals, if you will. They're very different types of community associations. But when you have a condominium transaction, that resale package must be delivered no later than 15 days prior to settlement. And then the buyer has 7 days to terminate the contract, which is kind of crazy to me. If a seller is going to wait that long, first of all, why would they get that out of the way sooner rather than later? But if I certainly get calls where sellers, maybe you're dealing with a very tight closing window, maybe you're going to close in 30 days. It can take some time to get those resale packages. A lot of condominiums have contracted with third-party providers, management companies that tend to drag their feet when they need to produce these documents. And certainly you want to be giving buyers the most current version of those documents. That is required. So be mindful, if you have a condominium property, yes, the seller has until 15 days prior to settlement, but then you're putting that transaction in a precarious position potentially because the buyer could terminate within a couple of weeks of closing. So just something to be mindful of. As I said, I try and infuse some best practices into these sessions, and certainly condominium and HOA transactions are no exception. In fact, I will make a quick plug while we're all here. As part of this year's forms update, I drafted a condominium and homeowners association forms practice guide. So this is a document available on our website, and it covers all of our condo and HOA forms, what they're meant to be used for, and when they're meant to be used. It's a 6-page document. If you have never engaged in a condo or HOA transaction, or perhaps you do them a lot and you just want to refresh your memory or have a point of reference, this is a great resource as well, and I encourage you to take advantage of it. And again, that's available on our website at mdrealtor.org on our statewide forms page. Shifting gears back to the contract of sale, as I stated, a lot of this material in Section 4 and in Section 5 has not changed from the previous version of the contract. It's just in a different location. So deferred water and sewer assessments, agriculturally assessed property, provisions pertaining to conservation easements and forest conservation and management program, and the Forest Conservation Act notice. They were all in the contract previously. They're still in the contract now. They're just in Section 4. Another common comment that I'll go ahead and shed some light on, since we're at the bottom of the page, is that there are no initial lines at the bottom of the pages of this contract. Initial lines, something that I'm working with the statewide forms committee this year to go through all of our forms and look at all initial lines that may be present. But initial lines, for the purpose of forming a contract, are not legally significant. What is legally significant is the signature at the bottom. That is what binds the parties to the agreement. When contracts are looked at by courts, when they're construed by lawyers, what we're looking for is logical, continuation, a document that's meant to be read together. And a contract form like this is obviously meant to be read one page after the other, all inclusive, just simply by the way of the fact that there are page numbers, the fact that you go logically from paragraph 10 to paragraph 11. It's very clear that this is one form, and have signature lines at the bottom of every page. All that typically has led to our questions of whether or not someone has a contract. One initial line is not executed on one page by one party. I've gotten that question a few times. Well, do we not have a contract? Yes, you still have a contract if everyone is signed at the bottom of page 10. So eliminating that potential compliance question, I think, was good. It also doesn't necessarily signify that a party has read or not read a particular page. By signing at the bottom, you're acknowledging and agreeing that you have read everything in the contract above the signature line. All right, let's see. Couple of questions in the chat. Beth Shear here. Hi, Beth. 29 and 30. If they do not apply, yeah, so this is a great question, Beth. If there is a blank space in the contract and something doesn't apply, putting NA is fine. You could also leave it blank. Either way is fine. If you feel like you want to put NA there for your own sanity, have at it. Please be my guest. And yeah, Roseanne, initials were there to make sure buyer saw that page. That's really just not what that means, legally speaking. What does signify that you've read is by signing at the bottom. And indeed, one other compliance issue I'll mention right now for those of you who use different platforms to assist your clients with electronically executing documents. So I'm thinking Dotloop, Zipform, DocuSign, those types of platforms. Oftentimes what those platforms will do, and this is not every platform, but some of them I have noticed do this, you will indicate a place where a party needs to sign or input information. And once that party clicks to affix their signature or initials there, it will zip them to the next place where they need to sign, not encouraging them to read the document. So really, having initial lines at the bottom of every page if they're using a platform that zips them through that page, not that the initial line signified having read anyway, but there are other issues pertaining to whether or not parties are actually reading that are certainly concerning to me. What I will encourage is providing, for example, if you're working with a buyer and you're just at the outset of starting to work with them, sending them PDF copies of our contract of sale and some of those commonly used addenda in advance, just giving them the opportunity. Here's the forms we're going to be using to prepare an offer. I'd encourage you to familiarize yourself with this language. And if you have any questions, let me know, because I can call our legal hotline service and perhaps get some answers for you before we start writing offers. Same thing for sellers. Here's our form contract of sale. This is what we're going to be receiving offers on more likely than not. Take this opportunity, familiarize yourself with it. And if you have any questions, please let me know, and we can address those now before, perhaps we are in a multiple offer situation. We're trying to consider various offers, or just for your information at the outset. So moving through into section 5. Again, now we're talking about general disclosures. Again, a lot of information that has been in our contract of sale for some time. Paragraph 33 references that residential real property disclosure and disclaimer statement. I often see that form filled out incorrectly by sellers. I do go into Bright and sometimes look and see what agents are putting in the documents. When I don't see any documents in a listing, that gives me agita, as my mother, who's been a realtor for 18 years, would say. Because of course we want to be making that form available to prospective buyers, that residential real property disclosure and disclaimer statement. Of course, sellers have the option under Maryland law as to whether they choose to disclose. And if they are disclosing, they fill out those first 3 pages of that 4-page form in their entirety and sign at the bottom of page 3. If they're disclaiming, they fill out the very top line of page 1, which has the property address, and then they zip down to page 4 and they disclose any known latent defects, and then they sign at the bottom of page 4. Oftentimes I'll see that form, maybe they'll fill out the first 2 pages and then stop and then fill out page 4, or they'll sign both. It's one or the other. That is a Maryland Real Estate Commission form. If it was a Maryland Realtors form, I'd probably might consider having 2 separate forms for disclosure versus disclaimer, but for now it is one form. But very important to make sure prospective buyers have that form in hand prior to making an offer, because under state law, if they do not have that form in hand and the parties go under contract, that contract remains voidable by the buyer. So the buyer can void the contract at any time up until 5 days after they ultimately receive that disclosure and disclaimer statement. So really the best way to make sure that's available to the buyer is uploading it to Bright so that their agent can pull it off Bright and give it to them, and it's been made available to them to look at. And certainly in our contract, we advise buyers of their right to receive that document at the outset of a potential transaction. Yeah, heartburn, Jim, exactly, Ajita. My mom is from southern Italy. So let's see. Moving through general disclosures, of course, again, provisions pertaining to lead paint, the limited warranty. We have updated the link to our property insurance brochure, so this is now a good link to that information that we provide through our website. Notices and disclosures relating to flood and insurance and premiums and rate maps, the guarantee fund. Let's see. As I'm saying guarantee fund, just a quick aside. I was in a session with the Maryland Real Estate Educators Association a couple of weeks ago, and Michael Kasnick, the director of the Maryland Real Estate Commission, was present. And something that he let me know of in terms of a common real estate commission complaints these days. The commission itself filed 40 complaints against licensees quite recently, and they do this periodically against licensees who affirmed that they had completed their continuing education requirements when they were renewing their licenses, but had not in fact done so. So just a quick aside from your state association, make sure you're doing your CE in a timely fashion. I know Harcard does a great job of offering CE to all of you, but make sure you're keeping on top of those CE credit requirements, because the commission will have no problem fining you $1,500 plus a $100 administrative fee for stating in your license renewal that you have done your CE, but in fact, not having done it. So just be mindful of that as a quick aside. But shifting back to the contract, again, notices pertaining to wetlands, Chesapeake and Atlantic coastal bays area, criminal activity, military installations, disclaimer notice to the parties regarding brokers representation, and the homestead property tax credit notice and other property tax notices. Section 6, besides all the very familiar paragraphs, again, buyers notice of buyer's right to select settlement services providers. The deed and title paragraph has not changed. What has changed is our transfer charges paragraph. And I do spend a nice chunk of time talking about this because I want to try and ensure that our members understand both what Maryland law requires when it comes to transfer charges, but also what the agreement in our contract of sale between the parties is, the default agreement when it comes to these charges. So when I'm referencing transfer charges, of course, I'm talking about state transfer taxes and local transfer and recordation taxes. And what Maryland law says with regard to those, who is to pay those charges when you have an in general transaction. By in general, I mean a transaction that does not involve a Maryland first-time homebuyer. What Maryland law says is that the parties are to split those charges equally. So state transfer tax, local transfer and recordation taxes are to be split equally unless the parties reach a different written agreement in that regard. So in our old forms, we did not have a place for the parties to actually state a different agreement other than an equal split, unless they did it on a separate, basically blank addendum or blank sheet of paper. Now we do have that space. So if the parties are going to be dividing everything equally, you don't have to put anything in the space. You can certainly put NA if you'd like to. But if they are going to agree to something different, for example, seller to pay all state and local transfer taxes and recordation taxes, that could be stated here in this line. Again, if an equal split is going to be done, that is the default. That is what's stated in our contract. Nothing different from what the law provides for, but it is expressly stated in the contract that they are dividing those charges equally. Nothing else needs to be done if that's going to be the case. Now, if a first-time Maryland homebuyer is in the mix, first, I'm going to tell you what the law says, and then I'm going to tell you what the law allows for, which is what we have in our contract. Maryland law states that when a first-time Maryland homebuyer is purchasing a home, the seller will pay all local transfer and recordation taxes. It also states that the amount of state transfer tax that the state will collect, so remember, typically in a transaction, the state is collecting 0.5% as state transfer tax. When you have a first-time Maryland homebuyer, that amount is reduced to 0.25%, and the statute says that that amount, that 0.25%, shall be paid entirely by the seller. So remember, in a typical transaction, a seller would be paying that anyway, right? Because that's half of the state transfer tax, 0.25%. The total amount the state typically wants to collect is 0.5%. But when you have that first-time Maryland homebuyer, the state reduces that amount to 0.25%, and then that remaining 0.25% shall be paid by the seller. That's what Maryland law states. But what this law also states is the parties can agree to something different. They can agree to something different in writing. And that's what our contract has historically had and what it continues to have. The different agreement, the written agreement as stated in the contract, is that the parties will split equally all local transfer and recordation taxes, with the seller paying that 0.25% as is statutorily required. If the parties want to come to a different agreement about who's going to pay local transfer and recordation taxes, other than an equal split, which is the default language in the contract, that can be stated in paragraph 51B in that blank line. If the default, which is the seller paying that 0.25% and everything else being split, is fine with the parties, nothing needs to be put in that line. NA is fine. I'll give folks just a few seconds. If you have any questions about that, I'm happy to address them. I think when it came to the old language that we had, for those of you who were intimately familiar with our old contract, the transfer charges paragraph was paragraph 25. I would get a lot of questions about that paragraph, a lot of misunderstanding about what the actual agreement was in terms of transfer charges. And I think the main reason for that was because what that language tried to achieve was stating what the law was and then stating what the parties were agreed to. And that, as my friend Deb Hudson, I love using this phrase of hers, that would often get lost in the sauce. Parties would not quite understand the bottom line, if you will, of what all that language was trying to convey. So I think this language is a step certainly in the right direction versus what we had before. But seeing nothing in the chat, I'll go ahead and wrap up talking about the residential contract of sale. Certainly we've tweaked the Maryland non-residential seller, non-resident seller paragraph. If sellers are Maryland non-residents, withholding tax from the proceeds of the sale shall be withheld at the time of settlement. And we've included resources where sellers can find more information. There is a limited scope of exemptions to that withholding requirement. One of the more common ones is if you have a Maryland non-resident seller of a piece of property in Maryland that is going to engage in a 1031 exchange. That tax does not need to be withheld. That state tax does not need to be withheld if there's going to be a 1031 exchange. But of course, that's something that a seller needs to plan out.
James, there is a question. It says, what happens if there is a conflicting document? A conflicting document, oh boy. Conflicting document could be the Baltimore County addendum. Well, okay, let's see. Okay, if there's a few questions here. So a conflicting document could be the Baltimore County addendum. And maybe Linda, if you want to hop on with voice, maybe flesh that out a little bit more for me. And I can't hear Linda. I'm not sure if her mic is on. I don't see her. Let's see, where is she?
But generally speaking, if you have conflicting terms in a contract, that's not good, because unless the parties are going to come to an agreement after you have a contract, picking one of the term, so you have two different terms, they conflict with one another, unless the parties are going to come to an agreement about the way forward, you then are setting the parties up for a dispute. But if
There's another question in there
if there's
too.
a first-time home buyer and it's reduced to 0.25%, is it possible to have the 0.25% covered by the buyer? So essentially the seller doesn't cover it. What I will say in that regard is that the state is saying they require to collect that 0.25% from the seller. There may be a way to accomplish some type of credit or reimbursement from the buyer to the seller, but that's something that would need to be discussed perhaps with the title officer. And Linda, I'm not, one thing I am very familiar with are our statewide forms. I know that many of our local boards and associations have their own forms. If there is a particular conflict with that Baltimore County addendum or addendum of clauses, I'll go ahead and put my email address in the chat, and you're welcome to point that out to me, but I don't have intimate familiarity with all of our local boards' forms, unfortunately. I say unfortunately, I think it would be that would be quite a broadening of the scope of what we do here at Maryland Realtors. So if the seller,
There's one, does one form supersede another?
right, I wouldn't be able to, without looking at that document, I wouldn't be able to answer that question.
And then if the seller must pay 25%, why is there a blank from anything for anything different?
Right. So if you read the sentence that precedes that blank, payment of recordation taxes, which are levied by local jurisdictions, and local transfer taxes will be divided equally unless otherwise stated. So the parties can come to an agreement about those, a different agreement about those charges, but that 0.25% of state transfer tax, the statute very simply says that it shall be paid by the seller. There's really no way around that. Those funds need to come from the seller and go to the state. That's what the state says. Yep. You're welcome, Erica. No problem. All right. So to wrap up this document, a few tweaks made to the property owner's title insurance paragraph. Just wanting to emphasize the distinction between title insurance issued to a lender versus title insurance issued to a property owner. Policies issued to lenders do not protect buyers from losses caused by a title defect, and certainly brokers are not warranting the condition of title either. Finally, Section 7, you'll see a lot of familiar provisions that, again, were in the contract, the default paragraph, the mediation of disputes paragraph. So our contract still requires that the parties at least first attempt to engage in mediation if they have a dispute, both prior to initiating the litigation process. If they want to file a lawsuit in connection with a dispute, they're first binding themselves to at least participating in mediation. Our attorney's fees paragraph, and then finally, just adding a definition to our date of contract acceptance line. So the date of contract acceptance is the date on which all final initials and signatures of all parties have been affixed to this form, thereby creating a contract. That is what the date of contract acceptance is. One little thing that I meant to mention, talking about the transfer charges paragraph, certainly if you have a first-time Maryland home buyer, you want to check that box, because in order to facilitate that reduction of the state transfer tax, first-time Maryland home buyers rather, need to fill out certain forms, sign affidavits at settlement, affirming that they are in fact a first-time Maryland home buyer in order to effectuate the waiver of that state transfer tax. All right, we've got plenty of time. I'm gonna go ahead and discuss some of the other new and modified forms for this year.
There's another one. Is there a recommendation who puts the date there?
So ideally that would be the individual who signs last, thereby forming a contract, or their agent. It could be the other agent as well. There is no requirement that it be any particular person, but that date should be in there so that you have something to calculate all the deadlines and due dates off of. Yep. All right. Got it. Okay. So post-settlement occupancy agreement. This was a very frequently requested document from many of our members, especially over the last couple of years. I would say, though, that it is not one of my favorite documents in our statewide forms library, if I were to have favorites, mostly because post-settlement occupancy just simply opens the door, sets the stage for disputes. Frequently when I get calls on the legal hotline about post-settlement occupancy, it's because there's a problem, and realtors who have already, the settlement's already taken place, of course, they're now finding themselves in the position where they are dealing with these issues perhaps weeks or months after settlement. If a seller does need a period of post-settlement occupancy, and I certainly understand that there are certain cases where that's a requirement of a seller, but I think it's not something to be taken lightly and something for the parties to give some consideration to if that's going to be the case. But we do have this form available now. A couple of points that I want to emphasize with this form. So this form has been designed not to, for the term of occupancy, not to exceed 60 days. And there's a specific reason for that. So when properties are financed by buyers who are seeking to occupy those properties as their owner occupied primary residence, typically mortgage lenders within those documents require buyers to affirm that they will be occupying that property within 60 days. So certainly if a seller had a period of post-settlement occupancy that exceeded 60 days, that could be a problem for the buyer. So if a seller needs more than 60 days for post-settlement occupancy, this form is really not designed for that. It's something that a buyer could potentially raise as a possibility with their mortgage lender. But generally speaking, your standard financing documents are not going to require a buyer to occupy that property within 60 days if it's intended to be their primary residence. In terms of how this agreement is structured, so it's not an addendum to the contract, it's its own contractual agreement, it's a separate contract, and it's not designed to form a landlord-tenant relationship. We do not want to be granting sellers the rights that tenants in Maryland have. We do not want to make landlords out of buyers. What this form does is allows a buyer to grant to a seller a license to remain in a property for no more than 60 days. No landlord-tenant relationship is created, and indeed, it is specifically stated later on in the form that we're not creating a landlord-tenant relationship. In terms of how a buyer may be compensated for the post-settlement occupancy, there is the ability for the buyer for the seller to pay the carrying cost of buyer or a flat daily rate with a calculation of what that total amount would be, as well as nominal consideration. So remember, in order to have an enforceable contract, you have to have consideration. Common law dictates that contracts can't be supported by $0. That is no consideration. Nominal consideration is lawyer speak for consideration in name only, if you will. So if the seller is not going to be paying the buyer for the post-settlement occupancy, you'd want to have the party's initial on line 1A, nominal consideration. There's consideration, legally speaking, but there's no money exchanging hands. There are provisions in here pertaining to a security deposit, acceptance of the property at the end of the term of occupancy in the same condition as the contract of sale dictated, the seller to pay utilities, a framework for conducting a final inspection and dealing with any deficiencies that might be noted, as well as how the security deposit may be dispersed. A place for the third party, the escrow agent who may be holding that deposit, to agree to perform the duties that are set forth herein. And then provisions for property access by the buyer, that express disclaimer that a landlord-tenant relationship is not being created, and how the property is to be insured during the period of post-settlement occupancy. Certainly, a lot of these provisions, I've gotten a lot of questions from members over the last few months about issues related to those things when those issues were not contained in whatever form or blank addendum was used to memorialize the post-settlement occupancy. So we sought to address some of those common issues with this form. All right, Erica has a question. If someone has been added to title via a quitclaim deed and did not buy the house and later wanted to purchase a home, could they be considered a first-time home buyer? That is a question that I'm happy to address offline, Erica. If you want to shoot me an email, I'll go ahead and put my email address in here. I do kind of want to stick to questions related to the forms because I know we do have a limited amount of time and I want to make sure that there's enough time to get through everything. But I'll go ahead and put my email address in there again. Shifting to the next document. So this document really going to be more applicable to homes that are on septic systems within the Chesapeake Bay critical area. So the disclosure of ATU, BAT on-site sewage disposal systems. These are newer types of septic systems. They started being installed more commonly in 2015 and after. These systems are designed to remove more or do a better job of removing nitrogen from septic effluent such that it does not flow into the groundwater and potentially contaminate waterways such as the Chesapeake Bay, make it more difficult for wildlife to flourish or thrive in those waterways. So these types of septic systems, sellers, if a new septic system has been installed in a property within the last 7-8 years or so, there's a strong likelihood that it is one of these types of septic systems. ATU stands for aerobic treatment unit, and BAT stands for best available technology. The fact is that these types of systems are subject to a scope of regulations set by the state, and buyers should be on notice of the existence of those regulations because they have some things they need to comply with if they're going to purchase the property. Homeowners that have these systems in place have to have them inspected on an annual basis. And in fact, when the system is installed, they have to have included with that installation, with the sale of that system to the homeowner, a 2-year operation and maintenance contract and a 2-year warranty. So sellers who have these systems installed on their properties, they're going to know that they have the system. And certainly buyers need to be aware of the fact that they need to continue with an annual inspection by a certified service provider on that system. And there's a link here to a list of those providers. Homeowners themselves can become certified if they want to. But what this form does requires that sellers disclose all information that they have pertaining to the system, any documents or inspection records, and provide the name and contact information of the certified service provider who most recently serviced the system, and as well as notify that service provider of the fact that the property is being sold. Let's see, that's a pretty quick form, but it is a new addition to the statewide forms library. Let's see, that's the old property inspections addendum. We don't want to look at that. Conventional financing addendum, there was an addition made to this form. If you go to the bottom, you'll see that paragraph 7 is our appraisal contingency paragraph, and everything that is not highlighted here has been in this form for quite some time. Where things didn't quite add up, so to speak, with this form was when it came to situations, of course, where the property failed to appraise at or above the purchase price. So buyer had the opportunity to request that the price of the property be reduced to the appraised value. And then seller has the opportunity to agree to reduce the purchase price or decline to reduce the purchase price. Once that, if the seller was to decline, the buyer had the opportunity in this very last paragraph here to either declare the contract null and void or agree to purchase the property at the purchase price, notwithstanding the appraised value of the property. There was a gap, though, in that if the buyer failed to make one of those elections in response to a seller's declining to reduce the purchase price to the appraised value, what would happen? There was sort of a limbo there. So the default language was agreed to by the statewide forms committee that a buyer's failure to provide written notice in response to a seller declining to reduce the purchase price, that would automatically constitute the buyer's agreement to elect to purchase the property at the purchase price. So that is the default there. Very important that, of course, buyers are reviewing this language and that their agents are also cognizant of deadlines, response deadlines in this regard, to make sure that their clients are aware that, okay, if we have a deadline to respond to something, we need to make sure that we're responding in accordance with the form and in a timely fashion. Any questions that I can answer about anything that I have talked about at this point? Happy to circle back to any documents that I've talked about. Let's see.
There is one in the chat. If you have a seller that is not willing to make any repairs or put additional money into the house, how can we as listing agents make this possible now?
So if a seller's not willing to make any repairs, that, as it has always been, is a representation made by the seller. Selling as is. Seller will make no repairs. That could be put in agent comments in Bright. It could be included in the body of a listing. As I described earlier, the as-is addendum did not prevent a buyer from making such requests, or prevent a seller from doing any of those things. It certainly did not function that way, even though that may have been the way it was intended to function. It was quite common, as I said earlier, for buyers to make repair requests lest they decide to terminate the contract, and sellers who may have previously represented, we will make no repairs or offer no credits, to suddenly have money available to do those things, or someone to put up money for those things in order to save the transaction. So that's really a representation made by the seller. Janelle, you had a question about the property inspections addenda.
Yes, I thought I had it, but I just want to make sure because I was taking notes to take back to my brokerage. So in the property inspection process on B, the first and second part. So right to terminate and negotiate. I know it's an or, and I know with the negotiate, you have to make that notification by the end of, let's say, the 14 days that you noted. So the right to terminate ends at that 14 days as well, and they proceed, or the terminate could be any time throughout the process to the end.
No. So you have a choice within the deadline time frame, right?
Right.
You can either terminate or you can choose to negotiate. Once you choose to negotiate, you cannot circle back if you happen to still be before the deadline and terminate, because you're electing to negotiate in lieu of terminating the contract.
Right. But so if we don't negotiate, I think the concern that we had talked about before in the brokerage was the right to terminate. So let's say that, they're fine with the inspections, they don't want to negotiate, but you get past and you're farther along in the process. Can they use that right to terminate later on, or are we bound to that? We're terminating within that 14 days.
So buyer's right to terminate the contract as stated in this subsection expires at the deadline. That's the last sentence. Of
Okay, so I just wanted to make sure I was on the right track. Okay, thank you.
course.
I have something on the same lines.
Yeah.
Understand that the deadline, everything expires on the deadline for termination, negotiation. So now the buyer has submitted the repair request, and now we're going to start in new timeframes, correct?
Right.
Now the seller has within 5 days of receiving that notice. So the deadline goes away of the initial time frame for inspection, and now we're in the new timeframes.
Correct.
Okay, thank you.
The contract now allows the buyers to ask for repairs. The seller now have no idea of the buyer's intent when accepting the offer.
I hear that. Still, though, that was also the case with the as-is addendum. Buyers could still make requests for repairs. There was nothing in that form that prevented buyers from making requests of sellers, and it in fact happened quite frequently.
So you're saying now there is?
Well, the buyer has the choice based on the content of the form. They can terminate or they can negotiate.
Okay, I see what you're saying. All right.
Tina, you still have your hand up. If you want to lower it if you don't have a question. Thank you.
And certainly if a seller is not willing to entertain repair requests, it could be represented to prospective buyers. Buyers welcome to exercise their right to terminate pursuant to the property inspections addendum, but they will not consider any requests for repairs. Any other questions?
Can I ask you one more question about that? What was your recommendation on why not to strike the right to terminate? Because I think the conversation in my brokerage came up about, a seller, it might be a stronger offer if you get rid of that right to terminate. So what was the reason you said not to strike?
So if you strike the right to terminate, it may be perceived as this by a seller, okay, buyers, strengthening their offer by eliminating their right to terminate. Well, in the event a property inspections report or multiple property inspections reports uncover a lot of issues, and a buyer is suddenly no longer inclined to purchase the property under any circumstances, whether a seller wants to do repairs or not, that buyer's way out potentially is to request every deficiency stated on all of those inspection reports with their written request for repairs, putting the seller in the position that, well, either we agree to do everything the buyer's requesting or we don't. And if we don't, the buyer can terminate the contract anyway. And then the seller and their listing agent are saddled with all of the information that's been made known to them pursuant to that inspection negotiation that didn't go anywhere. Absolutely, my pleasure. Any other questions?
Well, he's on, guys. Suck it out of him. He definitely has all the answers or can help you as much as you can. He's here to help you.
I have all the, geez, Kathy, that's all the answers, huh?
Oh, I will.
I'll go ahead and put my, I do totally understand though, Kathy, and this has been the case in a lot of these sessions I've done across the state. Because sometimes people need time to digest a lot of information, and we're certainly available to answer follow-up questions. I put my email address in the chat again. You're welcome to email me directly, within the next couple of weeks or so if something comes up and you'd like to follow up on something that I discussed here. Of course, again, I'll plug our legal hotline, a member benefit available to all of you. Please take advantage of the legal hotline. I love when I get calls in advance of issues becoming problems because we can then, resolve things before disputes arise.
I had a little quick thought. I have just been involved in like a Pennsylvania contract and another, not involved, but referred Florida person. And I just thought one of the really nicest things on those contracts is every line has a number.
Yeah, Tina, that's actually something that someone suggested recently. So we will be considering that. I think that's probably something we'd have to outsource because I'm not going to put numbers on every line of every form we have. But that's certainly, there's strong potential for that update.
So to reference something, they just said line 231, and then
Yep.
and then I think it's a good understanding for us all as well. Maybe, who knows?
No, I definitely see the benefits to that, and that's something the statewide forms committee will be considering this year.
Especially now with the changes as they are, and we're just having to wrap our head around it a little more.
And one thing I noticed in looking at a lot of our forms, like for example, the conventional financing addendum. So we have paragraph 7 here. There are a bunch of subparagraphs, but there's no subparagraph numbers. And certainly with the line numbers, it would make it a lot easy for me to, like in a hotline situation, well, a member's asking me about lines 30 through 35, then I can really hone in on that paragraph and we can discuss the exact language. So it's
No addendum numbers.
What's that?
No more addendum numbers. I mean, they could have been gone for a while and I just didn't pay attention, but the addendums don't have numbers, they're just having names.
Right.
Or did we have that option before to number them? Was that how it went?
If they were numbered, that predates my
Okay.
employment here.
Space there for it, but
Yeah.
okay.
But
I'm just speaking from experience on it when there's lots of numbers and when you're have a number assigned each sentence, when you start changing things, those numbers can go all over the place. And I'm sure attorneys have documents because almost everything in legal legal world has line numbers and stuff, but I know when we've tried to change things in documents that have the line numbers, you almost have to retype the whole document.
Yeah, that's another consideration. And certainly if we were to do that, Kathy, I'd want it in a way that would allow for somewhat easy modification. But that's the thing, if we change one word, potentially everything is now on a different line number for the next version of that form.
Yeah.
In the legal world, I definitely found it most common for there to be line numbers on deposition transcripts. And those documents didn't change. The deposition was the deposition, but yeah, it's definitely something that the statewide forms committee will be considering.
Well, and legislative bills all have numbers on them too. That's so crazy. Yeah. Is there any other questions for James? Go ahead.
I want to say one thing. I appreciate the organization of the information, bringing things together as far as selecting of documents and all that. It just seems it's better. I just have to adjust, but I appreciate a lot of the good changes. So
I appreciate that feedback. And look, I've gotten a spectrum of comments and feedback on these forms, and I am listening. I have been taking a lot of notes at a lot of these sessions because at the end of the day, this is a member benefit for all of you. And I want it as much as possible to reflect the majority, right? I can't make everyone happy. One thing that I've talked about a lot with members is, they describe something to me and really what they're hoping for is a custom contract for their buyer for a particular property. And, with our statewide forms, of course, that's, not something we can accomplish, but certainly this is a big change. And I will say that a lot of folks have been receptive to a lot of the changes, and I appreciate that feedback, but also constructive feedback as well.
There was another comment in here, Beth want, is number 11. What is the intent of the paragraph? It is meant to list every document in the transaction.
That's a great question, Beth, and something that I have kind of taken in hand, if you will, because one thing I noticed when I joined Maryland Realtors was that there are some documents that are referenced in the contract of sale that we don't have a form for. So to answer your question specifically, yes, if you are, for example, disclosing your licensee status, by checking that box, you are ensuring that that disclosure becomes part of the contract. So very important to check off documents that are being made part of the contract, all these addenda and disclosures. That being said, I'll give you an example. So in section 2, payment of the purchase price, we have a checkbox for assumption addendum. One thing that I discovered in reviewing our statewide forms library is we actually don't have that as an addendum. So one of the things I'm hoping our statewide forms committee will consider this year, I have a list of those such documents, deciding whether or not we are going to go ahead and create forms for those documents. Linda, on disclosure of inclusions, exclusions, leased items, and utilities, I wish there was under leased items, there was a box that said no leased items. I could probably make that happen for you. I will write that down as an option. And you might be able to see that change sooner rather than later.
One of the things from the standpoint from the standpoint of the association, when this all took place, we were trying to get you or Kathleen in like the very first day, and there was a backlog. Plus, it hadn't even been approved until almost the end of September, and it was coming, October 1st. Hindsight, it would have been probably much better if this would have been effective January 1st. So it would have given us some time to get, the forms out to people and talk to them and understand these before 2 weeks before the actual date.
Hindsight is always 2020, isn't it?
Exactly.
I think the way that things panned out this year, a lot of these changes were only approved in late July. And we have always stuck to that October 1 deadline. Again, in hindsight, you're right, Kathy. If I had thought that it would be possible to implement those changes January 1 instead, if that had been an option, that may have been preferable. One thing I will say is there is some potential in January. There's a couple of points. For example, Linda's comment, the no leased items box. A couple of little tweaks like that that we are considering making effective January 1. Not major substantive overhaul changes, but certain little things that a lot of members have commented on that we don't necessarily need to wait a whole year to implement. Certainly, we don't want to be bombarding our members with changes left and right, but there is potential for that. And in future years, my plan, just for everyone's information, I really want to prioritize our local boards having first opportunity to get this information out. But also, I want to make sure that when it comes to information coming from the association, everyone has that information at the same time. So my plan for next year is to pre-record a webinar with our Director of Legal Affairs, Kathleen D'Artez, sometime in August, mid-August, such that that is then available online. Anyone can watch it at any time. And then prior to that, in July, reaching out to all of our local boards and saying, here is a set of dates on which we can do sessions like this, or perhaps a Q&A, assuming that your members have already watched what we'll have released in advance of that, offering that first to our local boards in late August or early September. This year was a different year. We had a lot more changes. Coming into the association last year, it was rather limited scope of changes in 2021. I maybe did 2 presentations on the new forms that entire year. This year, I've done dozens. And in future years, whether we have a lot of changes or a few, I just want to make sure that everyone has access to that information at the same time in the same format.
And this is probably knowledgeable to everybody, but one of the questions I had that came into the association is did the contract that was signed prior to October 1st, did it have to change over to the new contract because there were so many changes? And that was, I believe I had talked with you or Kathleen, and she said, no, you would continue that contract.
Absolutely. So if you have an executed contract using the old forms, perhaps it was entered into prior to October 1, or an offer was submitted on the old forms on September 30th, for example, and the folks went under contracts after October 1, those parties are bound to the terms they agreed to, whether they're on the old forms or the new forms. This year, we did not have a situation where, and sometimes this is the case in other years, we've had a legislative update where a contract is required to contain certain verbiage. That wasn't really the case this year. We just changed a lot of the existing provisions. So yes, so if you have a contract on the old forms, you're in the process of going through those contingencies or that pendency of that contract, you're sticking to that.
And just a little plug for the association, we are using the zip forms from Lone Wolf. We are paying for that, and Maryland is going to be picking up half of that cost coming in the fourth quarter. So if you're not using, or if you want to use them, please let us know. And like I said, it's free. It's not there's a certain level in which we're using or that we're providing free. So, and we put it out there several times, and I think we have over 700 people who are using the Lone Wolf zip forms now.
That's an excellent member benefit.
Mm-hmm. Does anybody else have any questions for James? We greatly appreciate it. Like I said, this is all being recorded. We'll be happy to provide it to anybody. You can watch it over and over and over again. Pass it out to anybody you want to. And that's free of charge too.
Well, thank you to all for your time and attention today. It's my pleasure to be here with you. Again, Kathy, thanks so much for organizing this. This is great.
Thank you, James, for being here. Greatly appreciate it. And I know we paid a lot for you today. You might get some candy, I think. Your time was well worth. Thank you. I'll give them my big hand. Thanks a lot. Everybody's off screen, so I'm sure they're all clapping.
That's fine. Thank you so much, everyone.
Okay, I'm going to stop recording. Thank you, everybody.
Bye-bye.
Bye.